Michael Skakel's former attorney, Hubert Santos, was a bit more honest.
It's clear that my client did not get a fair shake. The probable killer was Tommy Skakel. Now, my client doesn't really want me to say that. It's his brother.
Which gets to the heart of the problem. The evidence presented at trial overwhelmingly points to one of the Skakel brothers as having been the killer. Murder weapon belonged to the family. She was last seen with Tommy. Michael admitted to being in a tree near her house that night. And Martha's own diary described her relationship with the Skakel brothers and the growing concern she had. Writing weeks before her death, Michael was so out of it, he was being a real a-hole. He kept telling me that I was leading Tom on. Michael jumps to conclusions, I really have to stop going over there. Now, that doesn't necessarily prove that anyone killed her, but there's the other evidence. But if Michael isn't willing to point the finger at his brother, is there really any merit to this lawsuit? Let's ask Michael Skakel's attorney, Stephan Seeger. Stephan, thanks for coming on the program. Long time. Good to see you again. All right, so let me ask you that bottom line question. You know, it doesn't sound like Michael's ready to point the finger at his brother Tommy, right?
I don't know why everybody thinks he has to point the finger at anybody. This is a civil rights lawsuit. It's a civil rights lawsuit about what happened to Michael, about how he spent 11 and a half years in jail for a crime he didn't commit, and he's a wrongfully convicted man. I don't know what it has to do with anything.
Well, I'll tell you, because in your lawsuit, you claim that the motivation was to convict a Kennedy cousin, that it was based on his name. His brother has the same name. His brother is the same situation. He's still a Kennedy cousin. They could have convicted a Kennedy cousin and gotten the same outcome. So if the motivation was, we got to convict a Kennedy cousin, you know, why not just go for Tommy Skakel? The reason, I think, from covering the case, as I recall, was Michael Skakel didn't want back then to point the finger at Tommy. And as a result, the defense couldn't be presented that it's a lot more likely that Tommy did it. It doesn't seem to me this was a fundamental constitutional issue. It may have been a mistake, but part of the problem was that Michael himself didn't want to point the finger at Tommy.
Well, I mean, I was part of the original trial team. That's where we met. It wasn't something that that lead counsel decided to pursue. But in terms of this particular lawsuit, I still don't understand why the question about whether Michael should point his finger at a brother, why that has anything to do with the fact that he has been wronged and he's been wrongfully convicted. Does that change anything? He can point his finger at whoever the hell he wants. He can say, hey, my brother did it, or Ken Littleton did it, or two guys from the city came up and did it. But does that take away from the fact that the lead investigator in a case has a book deal with Len Levitt and he's got a pecuniary interest in the case and he hides that? Does that take anything away from the fact that they hide exculpatory evidence? That's what the gravamen is. The gravamen isn't, hey, Michael, you have to solve the murder case that the Greenwich PD didn't solve. It's not that simple, Dan.
If that's the case, the best way to do that is to say, hey, look, there's another guy here who they really should have been looking at from day one, but they didn't want to look at him. You guys don't want to say that because that's his brother.
No, that's not true at all. Michael Skakel would point the finger at his brother or anybody else if he believed that they were the killer in this case. I mean, that's no secret. I don't know where you're getting your information from, but again, if you talk about, if you know, I don't mean to be condescending.
Please.
I'm just saying this in a criminal case, you have more of a leg to stand on. Of course, you point fingers. It's called third-party culpability, pointing the finger at somebody to tell the jury, hey, it wasn't my client, but it could have been Mr. X, and it's always could have been. It's not that the defendant doesn't just prove somebody else did it. That's not the third-party culpability standard. Well, complicating the ability to put forward third-party culpability suspects in the trial was the fact that we had all sorts of evidence that was hidden from us. This whole moniker, this whole Kennedy cousin moniker has driven this case from the very beginning, starting out with Dominic Dunn talking about the rich and the wealthy and the famous getting a different standard of justice. That's all baloney. Michael Skakel served 11 and a half years in jail. What Kennedy cousin privilege did he get? It's ridiculous. It's laughable for people to conclude that. This lawsuit is about what the state did to Michael, what they put him through, and not only is Michael not guilty, and not only is he innocent, he didn't do this crime. The facts post-trial clearly illustrate that he was 11 miles away, not anywhere near the crime scene.
I always felt that I was curious why they didn't pursue Tommy more, the brother. That I'll admit. And I never said during the trial, oh, Michael Skakel did it. I was always thinking it's got to be one of the two of them. And And the fact that and you're right, that's not enough, right? You can't say it's one of the two of them, therefore we're going to pick one and we're going to prosecute him. Absolutely true. But this notion that sort of, oh my goodness, this was some grave miscarriage of justice because they went after a Kennedy cousin. That's the part that I'm challenging here. Thank you for watching. Go to newsnationnow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.